Hi students, welcome to Chapter 18, The Last in Abnormal Psychology, covering law, society, and the mental health profession. In this chapter, we look at psychological dysfunctioning of an individual that does not occur in isolation, because we know that all behavior occurs in these larger social contexts, and clinical scientists and practitioners do not conduct their work in isolation either. Two social institutions have a strong impact on the mental health profession. This is the legislative and judicial systems, collectively called the legal field. There are distinct aspects, psychology in the law and the law in psychology. And then there is forensic psychology, which intersects between the mental health field and the legal and judicial systems. And forensic psychologists, for example, conduct custody evaluations and testify in court and things of that nature. To arrive at just and appropriate punishments, the courts need to know whether defendants are responsible for committing crimes and capable of defending themselves in court. And these determinations are guided by the opinions of the forensic psychologists. Criminal commitment is when people are accused of crimes or judged to be mentally unstable. They're usually sent to a mental institution for treatment. They may be mentally unstable at the time of the crime, and if they're found not guilty by reason of insanity, they're committed until improved enough to be released. If they're mentally unstable at the time of trial, they are committed until competent to stand trial. There's differing views of judgments of mental instability. These judgments tend to be sometimes loopholes versus a just legal system that allows for extenuating circumstances such as mental instability. Just kind of depends on your perspective, what you believe. The practice of criminal commitment differs from country to country. In our country, insanity is a legal term. The defendant may have a mental disorder but not qualify for a legal definition of insanity. And there are some tests that are used to try to determine this particular situation. In 1955, the American Law Institute developed a test that combined aspects of the McNaughton or irresistible impulse and Durham tests. And in 1983, the American Psychiatric Association recommended a return to McNaughton. So now this is used in all cases in federal courts and in about half of state courts, except Idaho, Kansas, Montana, and Utah, which have done away with the insanity plea. During most of U.S. history, a successful insanity plea amounted to a long-term prison sentence, but today offenders are released earlier because there's greater effectiveness of drug therapies and other treatments in institutions. There's a growing reaction against extended institutionalization and greater emphasis on patient rights. Regardless of their state of mind at the time of a crime, defendants may be judged to be mentally incompetent to stand trial, as mentioned earlier. The requirement ensures that defendants understand the charges they are facing and they can work with their lawyers to present an adequate defense. This standard of competence was specified by the U.S. Supreme Court in 1960. When the issue of competence is raised, the judge will order a psychological evaluation, and then when found incompetent, there's assignment to a mental health facility until competent to stand trial. Every year in our country, large numbers of people with mental disorders are involuntarily committed to treatment. Typically, they are committed to mental institutions, but 46 states also have a form of outpatient civil commitment, and these laws have been controversial since they were put in place. Generally, the U.S. legal system permits involuntary commitment of individuals who are considered to be in need of treatment and dangerous to themselves or others. They may be suicidal or reckless and put others intentionally or unintentionally at risk. The state's authority to do this rests on its duties to protect the interests of the individual and of society. This is the principle of parens patriae, the parent of the country, which is kind of cited, and then also the principle of police power. Many states give clinicians the right to certify certain patients as needing temporary commitment and medication. This requires the agreement of two physicians and/or mental health professionals. By tradition, they're called the two PCs. The length of the stay, though, is often limited to 3 days. Flexibility of involuntary commitment laws peaked in 1962. The Supreme Court ruled that imprisoning people who suffered from drug addictions might violate the Constitution's ban on cruel and unusual punishment. As the public became aware of these issues, states passed stricter standards for commitment, and today, fewer people are institutionalized through civil commitment proceedings than in the past. Over the past 2 decades, court decisions and state and federal laws have expanded the rights of patients with mental disorders, and these include the right to both receive treatment and the right to refuse treatment. So patients have those rights. They have other rights as well. Patients who perform work in mental institutions are now guaranteed at least a minimum wage. Those released from state mental hospitals have a right to aftercare and appropriate community residence. And people with mental disorders have a right to receive treatment in the least restrictive facility available. In terms of the rights debate, while people with psychological disorders have civil rights that must be protected, many clinicians express concern that patients' rights rulings unintentionally deprive these patients of opportunities for recovery. And because clinicians often disagree, it seems appropriate for patients, advocates, and outside evaluators to play key roles in decision-making. There are other ways that the clinical and legal fields interact. During the past 25 years, the paths of mental health and legal professionals have crossed in 4 key areas: malpractice suits, professional boundaries, jury consultation, and psychological research of legal topics. We have ethical principles also that guide mental health professionals that are worth mentioning. Each profession has its own code of ethics. The code of the American Psychological Association is typical of many others, and it's highly respected. This code says that psychologists are permitted to offer advice. They may not conduct fraudulent research, plagiarize the work of others, or publish false data. Psychologists must acknowledge their limitations as well. Psychologists who make evaluations and testify in legal cases base their assessments on sufficient information and substantiate their findings appropriately. They may not take advantage of clients and students sexually or otherwise. They must follow the principle of confidentiality with 2 exceptions: a therapist in training to a supervisor and Tarasoff's duty to protect. In addition to ethics issues, we look at mental health services in the workplace as being a very important component of our services. Mental health professionals interact with the business and economic fields, and according to numerous surveys, work is the leading source of stress for people. 60% of absences from work are stress-related, and there are 2 means of providing mental health care in the workplace that have developed because of that: employee assistance programs and stress reduction and problem-solving seminars. Governmental economic decisions may influence the clinical field's treatment of people with severe mental disorders. We have talked about the deinstitutionalization movement and premature release of hospital patients into the community as an example of this. Government funding has increased for people with psychological disorders over the past 5 decades, but it is insufficient. Only 64% of mental services covered by the government are covered by the government, and the rest are covered by patients and private insurance companies. There's a large economic role of private insurance companies that has had a significant effect on the way clinicians have to practice. These include managed care programs and peer review systems. And managed care will often limit the number of sessions that can be provided, and peer review systems will often limit or define the type of treatment that can be provided. Insurance reimbursements for mental disorders are lower than those for psychological disorders, or physical disorders, rather. Technology and mental health is another context that we can talk about. Changing technology has had positive and negative effects on the mental health field. There are new triggers for the expression of abnormal behavior online, new psychological disorders such as internet use disorders, abnormal exhibitionistic behavior and social networking impact, and additions to clinical treatment. These are some of the positive things like computerized intervention programs, internet-based support groups, smartphone mental health apps, and wearable monitoring devices. Telemental health is provided routinely now, and mental health information websites abound. And we also just want to touch on the context of the person within the profession. All of the clinical researchers and practitioners in the mental health profession not only influence and are influenced by other institutions, but are also closely tied to their personal needs and goals. Clinicians bring to their work a set of psychological issues that may, along with other important factors, affect how they listen and respond to clients. And many go to therapy themselves. It is not uncommon, and it is something that is encouraged in graduate training. So all of these are different types of contextual considerations for the mental health field, and this concludes my comments on